Hi. I wanted to look at something called regulatory capture. And this is sort of I think it's an introduction to administrative law because it is one of the deals that we see. And hopefully, in the process of looking at regulatory capture, we also begin to see how regulation works. I believe this is taken somewhere in England. I'm not sure where. I think at Oxford, but I don't have a good note. Anyway, beautiful setting. All right. And the first thing we have to do, of course, is look at Eric Cartman, who tells people, "You will respect my authority." Um, when we're looking at regulatory agencies, we have to look at where do they get the authority to regulate. Ordinarily, it comes out of legislation, okay? And what usually happens is the Congress or the local House of Representatives or the local House and Senate, the local legislature, the state legislature, passes a law, the governor passes it, um, signs it into law, and usually they import, some agency will then get assigned to it, or usually, oftentimes, in the legislation itself, they say which agencies will govern what. Taxing authority, Internal Revenue Service. But if it relates to workers' rights, it might be the Department of Labor. Animal husbandry is probably going to Food and Drug Administration or something like that. Um, anyway, so what the regulatory body does is they try to administer the legislative program. The advantages to administrative agencies is that they can find people in the industry or from the industry or with training about the industry who have expertise in the field. They're much narrower focused people. Um, you know, EPA folks tend to be pretty good scientists. Now there are two types of agencies. There's the executive or the legislative. Um, the legislative agencies tend to serve only the legislative body, like the uh, government accounting office. Executive tends to be where most of the agencies are. And if you look at the Missouri Supreme Court, you'll see this very clearly because it essentially creates all of the agency departments. The Missouri Constitution does, rather. It goes on and on and on. I'm not going to pop over there. But one of the things that they do, and those of you who are accountants may or may not know this, but usually the agency will get the legislation and then they'll make a rule that sort of tries to enforce the legislation. So what usually happens is there's a role where they say, we think that automobiles should only have 0.00001 microcarbons of certain gases admitted, um, detectable 3 feet from the waste pipe, or you know two by a device two inserted 2 feet inside the exhaust pipe or whatever. And so what they'll do is they'll say, this is the rule we're going to propose, and then they publish this proposed rule. um, there are two types of ways they can do this. They can do this formally or informally. For the most part, they go with formal, particularly on something like a, you know, exhaust. They want to have a real good record of exactly what they've done. And they want feedback. They want feedback from the public, but they also want feedback from the industries that they're trying to regulate. And this is kind of where regulatory capture may or may not come in. I hope these slides work. I'm still a little loose on getting everything right. Um, Probably not the best example of a how to do slide stuff. I was just real proud of these hostas. So you probably can't read what I have here. I'm going to read it to you because it is a little challenging. This is promulgation and challenges. That is, the agency promulgates, they publish the rule, and then they accept challenges. Okay. So if we're looking at things like the Code of Federal Regulations, most commonly known as the CFR, and it will correlate with US code titles. The United States Code has 50 different titles. Uh, number one may or may not be Admiralty. I know that like 26, here I've got 26 CFR 318 should relate to 28 USC 318. No, that should be 28 CFR 318, and it should be 20. I can't remember. I get the there's this Code of Civil Procedure is either 26 or 28, and the Internal Revenue Code is either 26 or 28. I can't remember the title on those two. But if you're looking at Section 318 in the Internal Revenue Code, there should be a uh, corresponding CFR, Code of Federal Regulations, regulation, so that there are books that you can read the code, and right next to it, you can read, here's what the enforcement is on the regulations. There's also going to be usually some kind of reporting of what if administrative agencies or administrative law courts or federal district courts or maybe state courts, if they have the jurisdiction, usually in the Internal Revenue Service, not true. That's only federal courts that have that. If you find that you're going to be adversely affected by, or if you are adversely affected by the regulation and the way they enforce it, you may be forced to file a lawsuit. The hard part is that in order to overturn any agency ruling, we have to show that the agency rulemaking body or the agency bureaucrat or the agency system acted in an arbitrary and capricious fashion. That is, they woke up on the wrong side of the bed and just said, no, we don't care. This is our rule. We're not going to hear any argument you made. You probably can't read the little French part I have down on the bottom, i.e., id est, which is Latin for that is, bonne chance, mon ami. Good luck, my friend. What you're going to find, and this, you may have seen this, President Obama's last Supreme Court nominee was a guy named Merrick Garland. I hope I'm getting his name right. And the Republicans who ran the Senate said, we're not considering this guy. But the one thing I noticed about him was that he had 12 administrative law cases come up in front of him, and he had always deferred to the administrators. That's pretty typical. He was maybe a little heavier than others, but you've got maybe an 11 out of 12 possibility. It's sort of like the chances of me actually making contact against a major league pitcher. The only way I can do that is to step in front of the ball and take a 98-mile-an-hour fastball off the arm. Not a good idea, but that's about how well you're going to do with challenges to regulations. Once comment period is over, once they've gone to a final rule and everybody agrees or disagrees, your chances of overturning it are really pretty remote. Any of you who want to know what we have in terms of flowers here, the one reflected here is a butterfly bush, and then these are all hostas, and the photo should be turned 90 degrees to the left. One of the things we talk about is regulatory capture. What we find over time is that administrative bodies get captured, if you will, by the businesses they administer. It's not completely true, but the way it tends to work is an agency regulates an industry. The industry, they may think if the industry requires substantial reform, one of the risks for the agency is we may shut these people down. If we get to the point where we want to close every coal mine in the United States because they're dangerous and people get hurt and because the impact on the environment, guess what? the people who regulate coal mines are just made themselves unemployed too. So there's a little bit of back scratching, if you will. Is it completely so? No. I mean, they're still on opposite sides, um, but what we find sometimes is that the agency employees say, hey, look, we've had all these incidents. We've got to do something to help you. Why don't you guys come up with something that you think you can work with? We'll start there. Now we may toughen it up, and of course the business will walk in and go, oh, this is the best we can do. They'll kind of lowball it. So if you follow the Trump election, the idea of Trump's negotiating is I'm going to take a real hard line on this side, knowing that Putin's going to take a hard line on the other side. And hopefully we'll meet somewhere close to the middle. It may be unsatisfactory to both of us, but that's usually how agreements are okay. We'll live by it then because neither of us is perfectly happy, but we're somewhat happy or mostly happy. Um, One of the problems we get to, and I think I already covered this a little bit, who regulates the regulators? Um, the executive, generally, that is the governor or the president of the United States of America, governor of a state, has the power to name the top people. All right. Congress has shown over the years they're not really, for some reason, they don't seem to want to do this. Okay. Um, and so they oftentimes approve these people. But what we get below the top named leaders tend to be lifetime civil servants. And this is where we get into what we call the bureaucrats. These are the people who can be a little challenging to deal with on a day to day basis because their jobs are pretty secure. And it doesn't matter whether they are mean to their customer, the businesses that they're regulating or not, they're still going to get a paycheck. Um, so um, the governor oftentimes, every now and then, I don't know, I probably shouldn't say this, but there have been some overreach by the last two presidents of the United States of America in terms of giving bureaucrats a lot of power. And they've kind of gone around Congress. And Congress hasn't always been that upset with that because they, then, as Congress, aren't perceived as the dirty SOBs who put that regulation in place. It's some awful bureaucrat. So the congressional people maybe have the agencies doing the dirty work and sort of blaming it on the White House or the governor's mansion. Um, it takes Congress to come in and enact powers. As I'm dictating this about 10 days before, no, I guess 20 days before a very interesting president, Donald Trump, comes forth, however you want to view him, he's one of the first people to come out of either non-military or non-legislative background. He's really the first businessman to ever be the executive, and he is a CEO, so it's kind of interesting. Um, you know, Congress can do stuff to enact to curtail powers, but that can be limited because of the entrenched methods inside the bureaucracy. There are ways that the enforcement agents can kind of go around Congress. And finally, we get the courts that tend to defer to the agencies because the agents are expert in the field. Unless the people who are harmed by it can show they just made this thing up, it makes absolutely no scientific sense. And even there, it's just really hard. The courts tend to um, defer to the agencies, to the will of Congress, and to the orders of the executive. The presumption is that they are behaving lawfully. You've got a hard hurdle to overcome to show that they're not. The last thing I've got in here is state regulation. I think I've really, in many ways, covered it. In almost every state, it's really the executive branch that forms all of these things. They tend to come out of a constitution. At least in Missouri, that's very clear that they're constitutionally created. And then the legislator has some oversight over their activities. Where we find a lot of state regulation is actually we move it down to the county and municipality area where train noise, for instance, is a local issue. Um, these are independent organizations, but they tend to also be governed by what the counties do. Um, the last thing in this that we should talk about is the industry associations. This is a place where oftentimes the regulators and the regulated meet, that it's not at all unusual for top people in the Food and Drug Administration to be members of various trade associations that they regulate. This is a way for them to kind of informally rule make, if you will, to, sit down over a cup of coffee, have a lunch together, and talk about, hey, what can we do? How's this impacting you? Do informal stuff where the gloves are off, if you will. We're not under oath. We're not doing all that. That takes trust. It may be a way we build trust. But I think what we need to know as business people is that the regulators aren't necessarily in business to shut us down. They're in business to get us to comply with reasonable regulations. And they may need us as business people and as customers to come to them and say, hey, here's what's reasonable. Here's what we think you ought to be able to do. So regulatory capture, sometimes it happens, and some people claim, and I'm among them, that the Obamacare legislation was essentially drafted by the insurance companies so that they could control the market that was being assigned to them as a mandatory fix. And so they went in and drafted a lot of the legislation that we see because they said, look, we're going to have to make it work. We need to know what that language is before we get to the regulation because it takes you guys too long to issue regulations. Um, it's not the strongest example, perhaps, but you know, there's a big deal between the car companies and the EPA. The EPA may want zero emissions ultimately, but the car companies are like, guys, that's impossible. We're burning fossil fuel. But we think we can do this. Here's some technology. Give us 10 years to develop that. And EPA comes back, you can have 7. Well, we've already been playing with this for 5. We really need that extra 10, blah, blah. Okay, we can have 8. And then they'll take it. And they realize that at that point, that as push comes to shove, near the time when these are going to be hard implemented, if they've made scientific progress, they can oftentimes get the administrators to sort of back out and go, yeah, you can have an extension for compliance, but they give them those hard deadlines so that they are making progress and that they're always kind of keeping the door open. Thanks for listening. Hope that was fun.